Good morning, everyone, and welcome to Coffee Talk, our health industry seminar series. My name is Catherine Frelick, and I am delighted to be speaking to you this morning about consent and capacity, back to basics. Just a few housekeeping notes. We do have a number of people on the webinar this morning, so please keep your microphones muted. We will be opening up the chat for questions at the end of the presentation. I will try to get to everything, but if there are questions that we're not able to answer, I'm happy to answer them after the presentation. So without further ado, we are going to be talking about consent to treatment basics, capacity basics, as well as Bill 7 and some of the controversial amendments that have been made to the Fixing Long-Term Care Act and the Public Hospitals Act around ALC patients. Although the presentation will be focused on a lot of the individual requirements for consent, from a institutional or organizational level, it's important to ensure that you have policies and processes in place that allow for the ability to ensure that consent requirements are being met, and also to set out how within your organization consent is to be obtained, whether you require a written consent form or not. It's not something that is required under the legislation, but really to assist regulated health professionals to be able to meet their requirements under professional standards and guidelines, and the various pieces of legislation that address consent capacity. I've listed them on this slide. Obviously, there's the Healthcare Consent Act that deals with treatment, but there are also a number of other statutes that have implications for consent under the Mental Health Act, the Substitute Decisions Act, which deals with powers of attorney and guardianship and certain types of capacity assessments, and the Regulated Health Professions Act and individual professions legislation that sets out obligations on various professionals for consent to treatment. In addition to that, there is a large body of cases. So we have common law or court-made law, which have set out a number of different principles that form the basis of our legislation, the Healthcare Consent Act. So those principles include no treatment without consent. Lack of informed consent may constitute negligence or battery. And so that's part of the standard of care for health professionals, is to ensure that there is informed consent. And if there's a lack of informed consent, that could lead to a finding of negligence. A lot of these changes were really built on cases that came out of the 80s, where there was a move from paternalistic medicine, where physician knows best, to individual right of self-determination, including an individual's right to refuse or withdraw consent. One of the cases that sort of entrenched that principle was Millett and Shulman. That was a case where an individual had a card in their purse in an emergency situation. The staff found the card that said that the individual did not want blood products. The physician in this case went ahead and provided a blood transfusion. It was life-saving, but the individual ended up suing the physician because this was not something that they had wanted, and they had the right to refuse that treatment. So, looking at our legislation, the Healthcare Consent Act deals with 3 different areas: consent to treatment, consent for admission to care facilities, and by care facilities, we're really talking about long-term care homes. That's how that term is defined, as well as personal assistance services. Treatment is defined very broadly, really has anything that is done for a health-related purpose, with some exceptions, particularly those types of actions where there is no risk of harm, such as taking a health history or communicating a diagnosis. They're things that are required of health professionals, and it's not something that an individual needs to consent to. The obligation is on the health professional proposing treatment to ensure that it is not administered without the capable person's consent, or if they're incapable, their substitute decision maker. Health professionals may also seek consent for a plan of treatment. So treatment also includes a plan of treatment or a course of treatment. A course of treatment being something where there may be more than one application of that particular treatment over time, or a plan of treatment which may include a number of different elements, and may also look at problems that the individual is likely to have in the future, given their current condition. So, for example, individuals with dementia, it's a progressive disease. You can anticipate certain issues that are likely to come up in the future, and you can plan a course of treatment which will anticipate those problems that may occur in the future. It also includes the withholding or withdrawal of a treatment. So the basic requirements under the legislation, so consent must relate to the treatment. It's specific to the treatment that's being proposed. It must be informed, and we'll talk about what that means. It must be given voluntarily and not obtained through fraud or deception. So what is informed consent? So consent is a process. It's the communication of information, ensuring that the individual receives the information that a reasonable person would require in order to make the decision. So it's a bit of an objective test. It's a reasonable person, and not necessarily the particular individual that we're looking at, and making sure they have the information they need to make that decision. And by individual, that means either the capable patient or the incapable patient substitute decision maker. So they need information about the nature of the treatment, the expected benefits, material risks and side effects. And by material, we're really talking about those types of risks that may occur rarely but are very serious, or those types of risks that may not be as serious but occur frequently enough that they need to be disclosed to the individual. It includes alternative courses of action, an explanation of the consequences of having or not having the treatment, as well as answers to the individual's questions. There are protections under the legislation in a few areas. One where a health practitioner is acting in reliance on what they believe is valid consent or refusal, and also where the individual is administering or refrains from administering emergency treatment. Emergency treatment being treatment where the individual is at risk of severe suffering if the treatment is not administered promptly. The test for capacity is something that is set out in the legislation. It has been dealt with through the courts as well. The famous case of Starson versus Swayze was a Supreme Court of Canada decision. In that case, Professor Starson, a professor was an honorarium for the individual who actually was not a PhD. But he was an individual who was brilliant in his field. He did not want to receive medication for his mental disorder because he felt that he would not be able to do the things that he wanted to be able to do. He didn't have the clarity of mind, when he was being treated. And the court in that case really focused on the individual's ability to understand the information that's relevant to the decision, as well as their ability to appreciate the reasonable, foreseeable consequences of that decision or lack of decision. And in that case, Dr. Starson was able to demonstrate that he did have the ability. He had insight into his illness, and he was able to apply the situation to his own, in his own case, but that he was making a conscious decision not to consent to treatment. So he had the ability to, under both branches of the test, and whether or not he failed to understand was not, or whether it was in the best interest, were not relevant to that test. Under the legislation, capacity is presumed. Health professionals may rely on that presumption of capacity unless it's not reasonable in the circumstances. And whether or not it's not reasonable, it's not something that's defined, but it could be, that there's information that suggests that the individual, is not capable, whether that information is based on observation or from information that's received from others. Capacity may fluctuate depending on time or depending on the specific treatment, and there is no minimum age of consent. So again, the Healthcare Consent Act does not require an actual appreciation of the consequences. Failure to understand is not the same as the ability to understand. A person who's capable is entitled to disregard advice and to make unwise decisions. It often puts health professionals in a very difficult position when that's the case, but it is something that they are entitled to do. Substitute decision makers are not able to disregard such advice. They are required to follow the principles for decision making, which we'll talk about shortly, and which really deal with the individual's capable wishes or their best interests. And when determining capacity, again, it's when we're talking about treatment, it's the individual who's proposing treatment who determines capacity, but they can seek input from other members of the team or seek advice to help inform that assessment. Generally, if a patient is found to be incapable, there is an obligation to notify the patient of the finding and the consequences. This is sometimes called informal rights advice. It's not something that is required, such as under the Mental Health Act, where you need to have a rights advisor who provides that advice independently to an individual. This is information that is conveyed by a health professional and essentially letting them know that they have a right to appeal that finding to the Consent Capacity Board. If they do wish to contest the finding of incapacity, treatment can't be started until that issue has been dealt with, including to an appeal. And there is an exception where there's an emergency and it's necessary in order to prevent serious harm. The Healthcare Consent Act establishes a hierarchy of substitute decision makers. And when you're dealing with decision makers of equal rank, they are joint decision makers. So I've set out the hierarchy from the Act. The first categories are ones where the individual is the representative through a court process or through a legal document. So the highest hierarchy is a guardian of the person, followed by a power of attorney for personal care, where the individual has granted authority to an attorney or attorneys to make decisions on their behalf. The Consent Capacity Board has the ability to appoint a representative to make decisions on behalf of an individual. And then after that, the hierarchy is really by virtue of the individual's relationship to the patient. So spouse or partner, brothers or sisters, a child parent, or person who is entitled to provide consent in place of a parent, which may be the Children's Aid Society or another person who's been appointed, other relative, and then finally the public guardian and trustee is the decision maker of last resort if there is no one else in the hierarchy who is available to make the decision. Just a note about powers of attorney. The power of attorney must confer the authority to make treatment decisions. In other words, a power of attorney for property would not provide authority for an individual to make decisions about treatment. A power of attorney is a legal document. There are some basic requirements that need to be met in order for it to be a valid document. It must be in writing, it must be witnessed by two individuals, and the individual granting the attorney must have capacity to do so. The test to grant a power of attorney is lower than the test for capacity to consent to treatment. So even though someone may not be able to consent to treatment, they may still have authority or capacity to grant an attorney. Typically, if there's a lawyer involved, they will be the ones who will determine whether they have capacity to grant that attorney. You may also hear about advanced directives or living wills. These are documents that may qualify as a power of attorney, but only if they meet the legal requirements. The Healthcare Consent Act doesn't recognize, a living will or advanced directive. The Act deals with wishes of the individual while they're capable, and so that in the power of attorney or other document, the individual can set out what their wishes are in the future, if certain circumstances require for treatment. Just to note that friends or non-relatives can only be appointed as a substitute decision maker by way of a court order, a consent capacity board order, or through a power of attorney. So there are a number of requirements in order to act as a substitute decision maker, and these can be really important. Number one, the substitute decision maker themselves must be capable of making the treatment decisions. And we have certainly seen situations where the substitute decision maker themselves does not meet the test for capacity, in which case you would need to look to the next decision maker in the hierarchy to make that particular decision. There is no right of appeal if there is a finding that a substitute decision maker is not capable. And again, it's a determination that is made by the health professional proposing treatment as to whether they have capacity with respect to that decision. The individual must be over 16 years unless they're a parent. They must not be prohibited by a court order or a separation agreement. And those situations often come up when we're dealing with children and various custody and access situations. A person must be available, and by available, you must be able to communicate with them within a reasonable amount of time. What is reasonable may depend on the circumstances. If it's an emergency, you may need, there may be less time in order to be able to get that consent, and there may be a need to seek consent from an alternative substitute decision maker until you can speak to the person that is responsible for the decision. Finally, they have to be willing to act as the substitute decision maker. There may be cases where the individual is not willing or able to do so. The health professional who is proposing treatment is required to inform the substitute decision maker of their obligations in giving or refusing consent to treatment. So it's great that you have a substitute decision maker. They need to understand the basis upon which they are required to make a decision. And so the test, again, is set out in the Healthcare Consent Act. They must act in accordance with the individual's prior capable wishes, if those are known. And wishes can be expressed in a number of different ways. They can be verbal, they can be in something that's written, it can be in an advanced directive, or it can be by gesture. An individual who is pulling out a feeding tube, for example, may be determined that that is expressing a capable wish if they are if it's determined that that's the way they communicate and they are capable of making that decision. The wishes need to be applicable to the circumstances, so the particular treatment that is being proposed. And later wishes that are expressed prevail over earlier wishes regardless of form. So even if someone has a power of attorney, which identifies their wishes, they can change their mind if they're capable. They can indicate verbally or through another process that they have changed their mind. If there are no capable prior capable wishes, then the substitute decision maker is required to make the decision in accordance with the individual's best interests, which is based on their values and beliefs, quality of life, balancing risks and benefits, and looking at whether there are less restrictive options. So I'm going to change gears a little bit for the remainder of the presentation and talk about Bill 7 and amendments that have been made to the Fixing Long-Term Care Act and the Public Hospitals Act. These changes were made quite quickly without a lot of consultation, or quite controversial because they allow certain actions to be carried out without the consent of the patient. Issues relating to ALC are not new. They are issues that the health system has been struggling with for decades. Particularly with the issues that have been brought to light with COVID, and the need to ensure that beds are available, hospital beds are available for individuals who need them. The legislation was brought through very quickly and is now in place. So the Fixing Long-Term Care Act has a new definition, which is a definition of ALC patient, which is defined as a person who occupies a bed in a hospital, who has been designated by an attending clinician as not requiring the level of intensity of resources provided in the hospital. The attending physician is someone who's authorized under the Public Hospitals Act. So this would be a physician or a nurse practitioner or a midwife to issue a discharge order for the ALC patient. As I mentioned, there are new provisions which authorize certain actions to be carried out without the consent of the patient. There are parameters on determining which patients and which homes, and of course, implications for hospitals, long-term care homes, and placement coordinators. So under the legislation, attending clinicians who reasonably believe that a person may be eligible to a long-term care home can request a placement coordinator do a number of actions without the consent of the patient, including determining the individual's eligibility for admission to a long-term care home, selecting a home within a particular geographic area, sharing assessments and personal health information with the licensee of a long-term care home. Now, there have been many situations where the ability to carry out the placement process has been, I will say, frustrated because the individuals involved have not been agreeable to sharing the information necessary in order to proceed with the placement process or with placement in a long-term care home. So these provisions allow for the sharing of personal health information in certain circumstances. The placement coordinator can authorize the admission of a patient to a long-term care home and also transfer responsibility for placement to another placement coordinator if you are looking at a home in a different geographic area. So before these actions can be taken, reasonable efforts need to be obtained in order to obtain the individual's consent. And it's required really at every stage of the process before these more extreme measures are taken. Reasonable effort is not defined on the legislation, so one of the things that will be really important for all of those who are involved in the process is to ensure that you have documented processes and procedures to be able to demonstrate the efforts that have been taken, that they are documented, and that you're in a defensible position, or as defensible as possible if there is a challenge to that decision at a later date. The ALC patient or their substitute decision maker may decide to provide consent at certain stages, not all or some. The legislation does not authorize the use of restraints or physical transfer of an ALC patient to long-term care home without consent. So you're not able to what would essentially be an assault on the person if you are trying to move them without their consent. That's not something that's permitted under the legislation. And then finally, the amendments are not to be construed as being inconsistent with the Resident Bill of Rights. The Fixing Long-Term Care Act has a Resident Bill of Rights that entrenches the individual's rights, including as it relates to consent. These provisions supersede any of those requirements under the Resident Bill of Rights, or would not be considered inconsistent. Eligibility criteria for admission to a long-term care home has not changed. A placement coordinator is still required to determine eligibility based on the same criteria that they have always used. And where the individual does not provide consent for an assessor to assess the individual, they can base their conclusion on a review of the patient's existing hospital records. Once an ALC patient is deemed to be eligible for transfer, the placement coordinator will provide the information to the long-term care home, or will provide information about long-term care homes, wait times, vacancies. If there is no space in the individual's home of choice, or if they refuse to make a selection, the placement coordinator may select a home within a particular radius, 70 kilometers in southern Ontario, or in the north, 150 kilometers. The Public Hospitals Act Regulation 965 has also been amended. And this is important to highlight. The legislation has always provided that if a patient's no longer in need of treatment in the hospital, the attending clinician may make an order that the individual be discharged, and and communicate that order to the individual. The legislation requires that the hospital discharge the patient, and the patient is required to leave on the date set out in the order, subject to a 24-hour grace period. However, there's never been any ability to enforce those provisions. So if an individual refuses to participate in discharge planning or refuses to leave, the only recourse has been if they've refused a bed in certain circumstances, to consider the stay to be uninsured and charge a per diem. And of course, that's been very controversial. The per diems are very significant, and so there've been there's been controversy over the ability of hospitals to do that. Now, if a discharged patient remains, the hospital is authorized to charge the patient, and is actually required to charge the patient, a fee of $400 a day. A patient is no longer in need of treatment in the hospital if they have been designated as an ALC patient, and the patient's admission to a long-term care home has been authorized. So those are the two criteria that need to be met before the per diem can be charged, and those provisions are now in force. So the individuals can be charged that amount. There has been some guidance issued by Ontario Health. There's field guidance to home and community care support services placement coordinators, as well as an operational direction that was issued in October of this year to hospitals, home and community support services, and long-term care homes. This sets out a number of requirements, ostensibly to improve and standardize the discharge planning process. A lot of this is not new. Engaging in discharge planning early on and coordinating with partners has been one of the key strategies to try to address ALC issues. But now this has been formalized, and there are some additional requirements that are set out in the directive. Hospitals are required to ensure that they have updated discharge planning policies that have a clear articulation of their discharge policies and process, which needs to be provided to the individual upon admission, and it includes written communication. There needs to be ongoing dialogue about ALC designation, supported by written communication, written materials that articulate the long-term care placement process, verbal and written communication on any fees. So that would include the chronic care copayment while the individual is in hospital, and the $400 hospital per diem if the individual refuses to leave when there's been an order. And it requires a collaborative process with home and community care, hospitals and long-term care homes when planning patient discharge and transfer. So again, from a risk management perspective, it will be really important to ensure that you have these policies in place, that there are communications that are taking place throughout the process from admission until discharge, and that there are written materials that support that. There are examples that are provided in the operational direction. It's certainly something that ensuring that there is a consistent process amongst hospitals will also assist in ensuring that you're in a defensible position should there be a challenge. We have already heard that there will be charter challenges brought relating to the legislation, and we'll see how that unfolds. And with that, I would be happy to address any questions or comments. We have a little bit of time, so please enter your questions into the chat, and I'd be delighted to respond.
Hi, Catherine. We got a question on the chat box. Before we go to the question, we remind everybody that a survey, a poll is going to just show up on your screen. We appreciate your feedback. The question from M is, are psychological assessments considered part of treatment? I assume so, but just wanted to check.
Yes, the psychological assessment would be something that you would require consent for. So that, yes, it would be part of that.
We have another question from Kaylee. What happens when a person is identified as both POA and PC and property as it relates to capacity?
That's a very good question. So when you're looking at capacity for treatment, the determination is based on the assessment of the healthcare practitioner proposing treatment. A power of attorney for property may requires a different determination. So if the individual is in a mental health facility, is admitted to under the Mental Health Act, there's a requirement for the attending physician to assess the individual's capacity for finances, and to contact the public guardian and trustee if they are not capable of managing their finances. Aside from that, a capacity assessment for finances is something that would have to be requested. There's a process under the Substitute Decisions Act for requesting a financial capacity assessment. There are individuals who are qualified to conduct capacity assessments, and there is a fee for that type of assessment. So the tests are a little bit different, and the mechanisms for determining capacity are different.
And that was our last question.
Great. With that, I thank you very much for your time this morning. We will be having more sessions coming up in the new year. So stay tuned, and we will uh, circulate information about our sessions in coming up in January. Thank you very much.